This video is brought to you by AmerUSA.com, where you can screen tenants 24 hours a day, 7 days a week. In this episode, we will be discussing Oregon landlord tenant laws. The following is a summary of landlord tenant laws in the state of Oregon as they apply to residential rental property. Topics include disclosures, withholding rent, the right to enter, security deposits, eviction, increasing rent, and more. Required disclosures. Contact information. A landlord must disclose to the tenant in writing at or before the commencement of the tenancy the name and address of the person authorized to manage the premises and the owner of the premises or authorized agent for the purpose of service of process and receiving notices and demands. Pending legal proceedings. For premises containing no more than 4 dwelling units, the landlord must disclose to the tenant in writing before the execution of a lease if there is any outstanding notice of default, pending sale, pending suit to foreclose, or pending declaration of forfeiture. Utilities. A landlord must disclose to the tenant in writing at or before the commencement of the tenancy any utility or service that the tenant pays to a utility company or service provider that directly benefits the landlord or other tenants by being delivered to any area other than the tenant's dwelling unit. Recycling. In a city or county within the urban growth boundary of a city that has implemented a multifamily recycling service, a landlord who has 5 or more residential dwelling units on a single premises must notify new tenants at the time of entering into a lease agreement of the opportunity to recycle. Smoking policy. A landlord must disclose the smoking policy for the premises by stating whether smoking is prohibited on the premises, allowed anywhere on the premises, or only allowed in limited areas. If a landlord allows smoking in limited areas, the disclosure must identify those areas. Carbon monoxide. If a rental contains a CO source, such as a heater, fireplace, appliance, etc., that uses fuels that emit carbon monoxide as a byproduct of combustion, or an attached garage with an opening that communicates directly with a living space, the landlord must install 1 or more CO monitors and then give the tenant written instructions for testing the alarms before the tenant takes possession. Flood zone. If a dwelling unit is located in a 100-year floodplain, the landlord must provide notice in the lease agreement that the dwelling unit is located within the flood plain. If a landlord fails to provide such notice and the tenant of the dwelling unit suffers an uninsured loss due to flooding, the tenant may recover up to the equivalent of 2 months' rent for the loss from the landlord. Renter's insurance. A landlord may require tenants to maintain liability insurance, but only if the landlord obtains and maintains comparable liability insurance and provides coverage information to any tenant upon request, whether it's orally or in writing. Any landlord who requires tenants to obtain renter's insurance must disclose the requirement and amount in writing prior to entering into a lease agreement. Security deposit limit. Oregon has no limit on the amount collected for a security deposit, but a landlord may not ask for an additional deposit within the first year of a tenancy unless both parties agree and the deposit corresponds to a particular modification, such as adding a pet. Deadline for returning a security deposit. A landlord has 31 days to return a deposit once the tenant moves out. Late fees. As long as a late fee policy is included in the lease, a landlord can charge up to a maximum of 5% of the monthly rent, but not until the rent becomes more than 4 days past due. Increasing rent. On a month-to-month lease, a landlord must give tenants at least a 30-day written notice to raise rent or change another term. Longer lease agreements cannot be increased unless the agreement itself specifically addresses raising the rent. Withholding rent. If a landlord fails to provide any essential service within 48 hours of receiving a non-compliance notice from the tenant may either procure reasonable amounts of the essential service and deduct the actual cost from the rent, recover damages based on the diminished fair rental value of the unit, or seek other housing during that time while being excused from paying rent. Terminating tenancy and eviction. An unconditional 24-hour notice to quit may be used for incidents of violence or threats of violence by the tenant or a guest, intentionally causing substantial property damage, giving false information on an application within the past year regarding a criminal conviction, injuring or causing fear to someone as an act of discrimination, or a second failure to remove a pet causing substantial damage. All other lease violations allow for a conditional 14-day notice to cure with an additional 16 days to quit. However, only 10 days needs to be given to remove an unauthorized pet. The right to enter. A landlord must provide notice 24 hours in advance before entering the rental unit. For more information, additional laws and articles can be found at AmericanLandlord.com.